I'm gonna go ahead and turn on the live stream because it is 1 o'clock and we do have a quorum, so.
Okay.
Yeah. Yeah, Kyle probably join.
I'm sure he will. And we are live.
How many tissues?
Okay, we're going to go ahead and begin. The chair calls to order the September 27th meeting of the Kansas Governmental Ethics Commission. Welcome, commissioners and staff. Thanks for your attendance today. In your materials, you have today's agenda and the minutes from our prior meeting. Can anyone identify any corrections that need to be made to either the agenda or minutes as written? If there are none, I'll take a motion to approve so we can begin.
I would so move.
Thank you, Jane. Thank you, John. Motion has been seconded. Is there any additional discussion? Hearing none, all in favor of approving the motion to approve the agenda and minutes as written signify by saying aye.
Aye.
All opposed say nay. The motion passes. Turning to the agenda, we will begin with an update from the Civil Penalty Waiver Subcommittee.
Excellent. Well, greetings, everyone. We managed to meet a couple times, actually multiple times with staff, and then as a subcommittee on its own. We have a couple proposals to put in front of you. It's part of the packet. Essentially, long story made short, staff went through the history of what has been historically acceptable, historically not acceptable for good cause allowed under the statute and the regs. And we broke those into different categories. Some we agreed on, some we didn't agree on, but ultimately we have a kind of by consensus document to submit with instructions. And I would really say it's probably most advantageous if everyone would look at it with just like a ill-prepared mind, meaning the same thing that anyone else would just see this as a blank document and just let us know comments. I don't know if that's appropriate for right now or if that's appropriate for our next meeting or what, but for it to be done right, I think people do need to chew it a little bit.
You need a motion on this, Mr. Chairman?
Well, is the thought that we're reviewing this and that we'll take an action to, let's say, maybe formally approve at the next meeting, or do we want to do it in this meeting?
I think it's up to the committee, to the commission, not the subcommittee, but the commission as a whole.
What would you prefer, Mr. Chairman?
Just to give it a thorough examination, if everybody could take the time outside of this meeting to review, try to poke holes in it, try to make recommendations, I would suggest that we table it until the next meeting and then formally look to adopt it then. Just my cursory review of it, I think it's in line with the review of, or the forms that were shared at a prior meeting. I think it's largely in line with my expectations. And so I think it largely looks good, satisfactory. So thank you for taking the time on the subcommittee to put this together. I think this is a step in the right direction. So thank you all.
Are there any questions? I'm sorry.
Please,
Are there any?
Do any commissioners have questions?
This jury, I do on the financial hardship declaration. Just my cursory review of it is pretty thin. Monthly income and expenses. It reminds me maybe a simplified tax form. What did you earn? Send it in. I'm not sure we're going to get a good photograph of that hardship financial from just that one sheet.
Can I address this, Chris?
Yes, please.
Yeah.
This was the banker in me, Jerry. Basically, we decided that, if people are going to make this declaration, that they're either going to tell us the truth or they're not. And whatever, we don't want staff to have to review tax returns. So we made it just very simple. I mean, we discussed some very basic rule of thumb margins that as bankers we use to decide, if their income and expenses are going to be such that they have any additional income, et cetera. So we purposely made it pretty thin. It was a lot bigger the first and second go around, but as I said, we purposely made it thin and just made it reiterate that if you're lying to this, there are repercussions. So
But we really don't need to take any action on this if we want to take it up next time, do we, Mr. Chairman?
Yeah, I think that's the thought. I'd say if everyone could take time to just continue to take a look at it, I think all good ideas are welcomed. I think this is an excellent framework to work within. So unless any other commissioners have any comments they want to share now, we'll just plan to include it as an agenda item on our next meeting with the idea that we'll take a vote to approve and adopt.
I have a question.
Mr. Chairman,
Sure.
this is Andrew online. I just had one question about the financial declaration as well.
Sure.
Is there any way that we can make that sort of confidential? I just felt that it may be, not so great for these people that have to put all their financial information out in the public eye, considering it would be a public document.
Well, and that was another reason, Andrew, why we did thin it out, was because it is a public record. It is something that people would be entitled to see. And so didn't want to have tax returns and redacted social security numbers and all of that personal identification floating out there. So, and unless council has an opinion that somehow, what is discussed even in the open session would be exempt from open records, I think we have to make it available to the public.
Yeah, we talked about this as well, looked from the legal side, same thing. It's like Commissioner Berger said, it has to be public.
One thought that I had, just considering income and considering expenses, was there some threshold amount that's not specified on the form that you consider to be determinative of financial hardship?
We didn't make any pre-qualification that way.
Okay. All right. Well, we'll take it up at the next meeting.
And as a maybe a conjoined issue, would for the next meeting would also be whether or not this simply be, or the manner in which that it would be adopted, should it be adopted? Meaning, would it just be a guidance item for the commission? Is it do we move it into the regulatory side of things and turn it into a formal regulation? So as a subcommittee, that was beyond what our recommendations were or were not. But as far as what this commission needs to do next, that would be, I think, a conjoined step.
Sure. Presumably, when somebody would approach the commission and say they wanted to make a request of this time, they would be pointed toward the form, and basically all other submissions, it would have to go through this mechanism, right, in order to make a formal request of the commission.
Right, and there are some things you'll see in the instructions where we say the following items will not be acceptable. So in that sense, it's a bold statement. And it's one that if it's simply a guidance document for the commission, then we all just wasted a couple months. If it is something which is truly a regulatory effort, then we need to sincerely and soberly step into saying, okay, some things will not work.
Yeah.
No.
No, I see your point. As I understood the mandate, I believe this is something that we're wanting to have a real effect. And so I would defer to it in most instances. It would take really unique and exceptional circumstances to step outside of it, I would imagine.
Right, right. And I think we've had that discussion, but if we could have that on the agenda too next time.
Sure.
That'd be useful.
Sure.
Thank you.
Turning back to the agenda, we have an executive director's report.
I might note that I don't want us to skip the public comment. I'm guessing there probably isn't any, but I want to make sure there is a public comment bullet item on the agenda.
Sure.
public comment on the forum.
on the civil penalty waiver subcommittee
Oh,
update.
right. And I think we
Yeah.
did receive a piece of correspondence that was part of the packet. I think that was related to this item, but I wasn't sure.
I haven't seen it.
Yeah, I wasn't sure what you're referring to.
I don't think staff has that communication.
No.
Provide that with us next time.
A guy named Anthony Gallardo. Hello, I'd like to speak at the next commission regarding this formal request to waive fees. I don't know if that was just his or the
Oh, yes,
process.
that's just his. That is just
Okay.
his.
Thank you.
Is he here today or?
We sent him the team's notice. We'll talk when we get to the waiver requests.
Okay.
But I don't see him on the team's meeting right now.
Well, I take it that we have no public comment at this time, but of course we will, for the record, welcome that at the next meeting as well. We have an executive director's report. Mark, do you want to give us an update?
Sure. So two items on the report today. The first item, at the conclusion of the last commission meeting, there was a request for a report essentially outlining some of the things that we do, that commission staff does to secure report filing. And this is, there's a lot of steps that are taken. We view report filing as one of the preeminent issues that we deal with. It is extremely important that reports get filed. If they don't get filed, then there's no transparency gain for Kansans. There's much that is lost in that benefit. So in terms of how we go about securing that filing, there's a general approach that we use on the campaign finance side and on the lobbyist side, and individual cases may have some slight variance, but in general, when someone files for office, they get the campaign finance packet, which has contact info for us, it has due dates and a ton of reference materials and links. So if any question they have, even frequently asked questions, there's a lot of good reference items there, but it also does include those report due dates. 1 month prior to the deadline, treasurers will receive a memo reminding them of the upcoming due date, instructions, reminding them that if they don't file on time, there is a civil penalty. And also, again, our contact info should they have questions. 2 weeks prior to the deadline, both the candidate and the treasurer receive a reminder as well, reminding them again of the due date and instructions, the civil penalty that would incur if they filed late, and our contact info. After the report deadline, typically here we're talking about the July and October reports, the primary and general election report. The January report has a much longer grace period and is a little different than this. But for the primary and general election report, 2 days after the report deadline, we put the failure to file in the mail, which includes our notice and a warning of civil penalties that will accrue should they not continue to not file. We also frequently will call and email people trying to secure filing whenever possible. Sometimes that is more possible than others. On the lobbyist side, when someone registers as a lobbyist, they receive an initial email. Email is the primary form of communication. Lobbyists typically are very responsive to emails, and they also, when they register, they have to provide an email, unlike many candidates. So when they register, they receive information involving essentially how to be compliant as a lobbyist, including report deadlines, which don't change every year. On the campaign finance side, their reports, the deadlines do change specifically which day it is. It's always on the 10th of the relevant months on the lobbyist side. Now, 9 days before every deadline, so the first of the months where the report is due, lobbyists get an email reminding them of the deadline. That usually secures quite a few reports right off the bat. The day after the deadline, lobbyists with outstanding reports get another email warning them that their reports are past due and that a failure to file notice will be mailed that afternoon. In addition, that is also followed frequently with a phone call reminding them to file a report. And that afternoon, failure to files are put in the mail with the warning of the civil penalty, of course. I will note that the day after the deadline, there's frequently something around between 150 and 200 reports that are still outstanding at that time. And we are by the afternoon, we're down to 12 is about the average. There are very, very few failure to files that typically go out. And this is true of all of our compliance staff. And I know we talk about lobbying in particular frequently, but I do want to note that our compliance staff works very hard, and I appreciate everything that they do. It is great to see when we can help people actually file their reports when they've experienced some difficulties. And we can help them get to that point. So on the lobbyist side, I just wanted to note that even those later reminders end up securing quite a few reports, preventing a failure to file from going out in the first place. Failure to files are also sent certified, which means that they cost us between $6.50 and $8 every single time we do it. So it's not free for us to do. If we have 100 failure to files to send out, it's a significant cost to the agency. So it's great when we can knock that down, not just from obviously a compliance standpoint and for transparency, which are the critical aspects here, but also it's great to see that on the budget side as well. So we definitely appreciate that for a number of reasons. I can definitely take any questions on the steps for compliance before we go into the second part of the director report.
Nice summary.
Thank you.
Yeah.
Are there any of those notices that are statutorily or regulatorily required?
The failure to file is required.
The one
Beyond
after the
that,
fact?
yes, our extra reminders, things that we're trying to help people with, we're not required to send those. We're just trying to provide assistance to, in our experience, if we don't send some extra reminders, it's going to be a fairly high number of people who are not paying attention to the exact deadline, especially on the campaign finance side. When it's on the lobbyist side, you have a lot of people who they're professional people who this is what they do every year. It's a repeated game because it's the same people coming back over and over again. They know the law, they know how it works. On the campaign finance side, you have some first-time people who haven't done it before, some treasurers who haven't impacted the law in any way yet, who haven't filed reports before. So on the campaign finance side, it's sometimes a little bit more difficult, and those reminders are very helpful in our experience.
Do you think you could get emails for the non-lobbyists in the future, just to make your life a little bit easier, but still provide the good notice?
I'd love to require it. Right now, it's not required statutorily. We do have more emails now than we used to get, and that does help quite a bit because I'll be honest, phone calls are a fairly common focus for us when we're trying to secure compliance. But lately, in particular, the people who are still outstanding quite a bit after the report deadline, those are the people who also you try to call them and their mailbox is full and they are not claiming certified mail and things like that. So it's difficult sometimes to get in contact with some of those people. Email is usually fairly straightforward, and most people typically are responsive there, but it depends.
I appreciate you putting that together. I'm appreciative of the efforts to make it so that part of our role is not necessary. So that's always good.
Yeah.
Anytime we can make your life easier, that's definitely something we want to do as well.
Yeah. Thank you, Mark. Any other questions on that bullet? Okay. Discussion regarding civil fine hearings?
Sure. So I apologize. I won't read the memo to you, but there is okay, thanks. There's especially after the discussion that we're having about civil penalty waivers, I think that there's a related conversation that is worth having about the way we approach failure to file civil fines. So right now, if we have a report that is due and is not filed on time, and it's still not filed quite a bit after the deadline, we will file a complaint. It's heard for sufficiency, probable cause, set for a hearing. If at any time in that complaint process, that report is filed before the hearing actually occurs, it is the historical practice of the commission, typically, at least in the last decade or so, to dismiss those complaints unless the the respondent in that matter is someone who is a frequent offender, someone who clearly has not been deterred by civil penalties, who essentially the commission wants to ask, what do we need to do to help you be compliant in future? That's only happened, I think, 3 times in the last 7 years. So it's very rare when that happens. Typically, they are dismissed. I will note that when we have an election-sensitive report, so we have a report that's due 8 days before the primary election and before the general election, those reports are used by voters, and voters in Kansas have a right to be able to access and utilize that information to inform their votes. A report that is filed on the day of the election or the day after the election is still late to the point where we could file a complaint. And historically, we would dismiss those, even if it's quite a bit after the election. The voters never had an opportunity to view that information when considering their votes. So that is something that it is worth considering, is the fact that that is an irretrievable harm that is done to Kansas voters. Is that something that is worth in creating a situation where we, in those instances, would nonetheless have a fine hearing? I will note, this is not going to be an incredibly small number of fine hearings. There's probably going to be at least another half dozen a year. I haven't run numbers or anything like that to look at it, but I would imagine it's not going to be an incredibly small number of hearings that we would get, where we would end up with people who they filed their reports after the relevant election. It's also possible that if we did hold those fine hearings, we could set a general formula, something like kind of similar to what the FEC does in late filing, something like 10%, 15% of the contributions that they received in that period. So if someone did not receive anything in that period, then maybe there's a minimum amount or a maximum amount. There's a lot of things that could be done. Right now, the answer is to dismiss these and assume that the civil penalty is adequate to deter that conduct in future and to resolve any underlying harm to Kansas voters. So this is something that I thought was worth discussing, given that it's kind of an offshoot of the civil penalty discussion. And I'm entirely fine, obviously, with whatever the commission decides, but this is a related policy discussion, I think, that's worth having.
It's an interesting point, Mark. Any commissioners have comments?
I would agree that not filing depriving the voters of the opportunity to have that information is probably a serious thing. We should take it seriously.
Mark, is there anything in our current set of statutes and regulations that keys in on whether or not something is defined as election sensitive?
No, that phrase I'm only using to specifically reference the primary and general election reports. And here I'm talking about when we have someone who is running in the primary and general, so someone who is on the ballot that voters should have had an opportunity to view their report. So for example, if someone did not have a primary election, they weren't on the ballot in the primary and they filed after the primary date, I wouldn't view that as election sensitive. The voters weren't voting for them.
You mentioned the FEC. Are you aware of other states that have rules that penalize election sensitive, let's say, reports submitted late?
Not off the top of my head. There are obviously, every state is a little bit different in how they handle late filing in general. But for the FEC, I'm talking about I was referencing the formula that they use for late filing. Instead of it's a little bit more like our civil penalties, is that the amount of time that they're late, the amount they received in contributions, and whether or not the report was election sensitive are all things that are part of an FEC formula. And I don't think we need to be that complicated here, but I think that it's a model that is worth considering whether there's a simplified approach that's worth talking about for us.
I would echo what Commissioner Solbach was saying. I think in the terms of sensitivity, that is a very sensitive time for the voter and for the candidate, and something that we would want to have, greater authority over. Is there any statutory authority in existence right now that you're aware of that would give us that power, though?
We already do file those complaints. The commission can discretionarily dismiss a complaint if they feel like it.
And I was referring to the penalty aspect of it, though.
The formula. Well, the commission has that range of fines that they can assess in a civil fine hearing, up to $5,000 for a first offense. Setting a formula, some sort of as a guidance, is something that the commission could always depart from. But like we've talked about with guidance documents in general, if there's a departure from that guidance, there has to be a reason for it. So if someone comes in and says, for example, I missed the report because of this extremely serious issue, both myself and my treasurer were hospitalized during this entire period, we would have the fine hearing, but the hearing would essentially there would be a departure. There would not be a fine in that instance. The departure would be, and there would be just reason for that. So essentially it would be the creation of some sort of guidance formula for that. If the formula is even an approach the commission wants to do, that was just an idea on how to go forward with a scenario in which we kind of create a balance of how much were the voters deprived here. And generally, the more that the candidate received, the more that the information that the voters were deprived of.
Well, I'll be interested in seeing a more in-depth proposal in that regard as to what staff would be suggesting.
I'd be
Yeah.
happy to put something together. Caitlin and I can work on that, to put something together that as a form. I wanted to kind of take the temperature of the commission and see if this is
Right.
a direction that
else?
people were interested in.
No, I think you're right on point that this is an important issue. And if, from your viewpoint, it's one that we should address, then yeah, I would also encourage somewhat more detailed proposal with solid footing, kind of in our statutory authority.
Yes. We'll have that for the next meeting.
Okay.
Agree. I mean, it's not dissimilar to what we just did with the subcommittee. You
Yeah.
know, just kind of put the rails up a little bit.
A little more prescriptive. Yeah. No, I agree. Do any other commissioners have comments on this topic before we move on? Okay, the next item on the agenda is a general counsel's update.
Hi, so we talked about introducing this update as a way to resolve doors that are opened in prior meetings relating to the law that weren't necessarily closed in that meeting. So for instance, the two matters that I'll discuss today are a family law decision was brought up in the last meeting that may have implications on the language of upon information and belief. And then also a question was raised last meeting regarding the relevant standards that the commission applies at different levels, both through the investigation and through the complaint process. So the first thing I wanted to discuss was the family law case that was mentioned at the last meeting, which is in the materials, you have a more laid out memorandum. It is the matter of marriage of Ballman. It is an appellate court family law decision that did hold that upon information and belief is not sufficient for evidentiary purposes, but it was specific to a family law statute, which is KSA 233219, and it's about verified motions to change child custody arrangements. And the big issue in that case was that just having a verified motion upon information and belief alone was only unsupported factual assertions. There was no evidence. And so that is the issue of things proceeding only upon information and belief. But that is not how our process is set up under the Act. So not only are our complaints explicitly via statute 2541, 61, and 46-256 allow for our complaints to use upon information and belief in the language, but that is because the complaint initially is not the end of the inquiry. So we go through the process of filing a complaint. If the commission decides the complaint is sufficient based on the facts that are pleaded, then it moves to a probable cause inquiry, which has a higher evidentiary standard and more evidence is involved. So having the complaint itself use language of upon information and belief is not a problem factually because it's only the first step in the process. So the issues in that case not only don't apply to our statutes, but the underlying policy problems in that case are resolved with how our act is set up. So because there's additional evidence, while that case is insightful, it is not a problem for the way that our process functions. Before I move on, this also came up in, I believe, some of the pleadings that may be submitted, other pleadings, not just the complaint, but using the language upon information or belief or information and belief, if it's also supported with evidence, is maybe not the best use of the language, but the evidence there supporting the exhibits that support the factual claims resolve any evidentiary issues. Before I move on, do any of the commissioners have questions about that case?
Sounds good.
No.
I do.
Sure.
When looking through our statutes, I mean, obviously statutes are all different bodies of law, et cetera. But the verification itself still needs to be a verification, even if what they're verifying is a statement of fact or a statement upon information and belief.
Yes, and that's.
But
it have to
our
be.
verification form seems to be not a verification, but a statement that things are either true or upon information and belief are true. And I
Our
think
s-
that is an important distinction. I can verify a fact to be true. I can also verify that something upon information and belief is true. But I can't verify upon information and belief that facts may be true.
Yes, that's what I was saying. I think what you're saying tracks. The way that our statute is written, 4161, says that the complaints must state alleged facts either directly or upon information and belief. And
Right.
so you're right. Yeah, no, we agree. We're on the same page, I think.
Okay, so I think our verification itself may still need to be tuned.
I don't understand. I guess I don't see why, considering our
Yes, our-
statutes allow us to allege upon information and belief or directly.
But it still needs to be properly verified. And our verification language, I think, still says, you know, upon best of my knowledge or upon information and belief that it's being verified.
Verification is, sorry, go ahead, whoever was.
I was just going to say, Commissioner Berger, do you have a recommendation about what that verification might look like?
I think we just remove the language that says upon information and belief, and we remove any language of to the best of my knowledge. And where there are instances that the affiant or the person doing the verification doesn't know it to be a fact, they just include in the body of what they're verifying that upon information and belief, John Smith was a treasurer. Or, you know, Jane Doe was a treasurer.
I will read the language of the verification. I have it in front of
Mhm.
me, and I'm not revealing anything in executive. This is just the language for the verification. It says, I of name of
Yeah.
lawful age do swear or affirm that this complaint and any accompanying schedules and statements has been examined by me and to the best of my knowledge, information, and belief is true, correct, and complete.
I think that's sufficient.
I don't think that complies with the proper verification.
I would appreciate, I guess, I'm having trouble understanding where the problem is. So I would love to address it. I think I need
Yeah,
to.
We can
see
just
what
talk.
you need. Okay,
Yeah, I can give you a ring.
yeah, that'd be great.
I think that would be productive, yeah.
Yeah. Okay. Are there any other questions on that first point before I move on?
But thank you.
No.
Yeah, thank you. So the latter half of this update is pretty short. There were just a few questions raised last meeting about the standards that apply at each step of the process. Reasonable suspicion comes up in the context of issuing subpoenas, and that is a fairly low burden. The requirement also, reasonable suspicion is a particularized and objective basis for suspecting a violation. It's more than just a hunch, but it's not all the way to probable cause. It can arise. Yes. Is there a question? I thought there was a. Okay.
I think it's feedback on the phone.
Anyway, it's a fairly low burden, and the requirement also, to be clear, because I think there's been some confusion, not necessarily within last meeting, but in prior meetings. The requirement is to show that there is a reasonable suspicion of a violation of the Campaign Finance Act, not that there is reasonable suspicion that a particular individual committed a violation of the Campaign Finance Act. And that distinction is important because the issuance of subpoenas often comes up in 254158, which those subpoenas often go to witnesses or interested parties, not necessarily individuals that would have a complaint filed against them. So that is why that distinction, that's why I wanted to make that distinction a little clear, because I feel as if, again, not necessarily this previous meeting, but I've heard discussion Also, some of the legislative discussion last spring conflated the two as well. So reasonable suspicion is used when issuing subpoenas. Then sufficiency is the standard that the commission applies when evaluating complaints in the first meeting. Facts in a complaint must be sufficient to constitute a violation of the relevant law, and they are viewed in the light most favorable to the complainant. The commission views them similarly to Chapter 60 motion to dismiss. The final standard is probable cause, which, as we've already alluded to, requires additional evidence. And probable cause only exists if evidence is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the liability, essentially using the experience that you all have as a reasonable person, determine whether there's probable cause that a campaign finance or ethics violation occurred, and that standard comes up at the second meeting where the complaint is considered. And all the circumstances should be considered there as well. But that is all that I had specifically that I wanted to address with you all. There's a bit more, the final proof threshold is clear and convincing. That heightened standard comes up in our fine hearings when we get to that point. Clear and convincing is evidence that is sufficient to establish the truth of the facts and is highly probable. It's not necessarily more evidence than preponderance, as is seen in civil cases, but it's based on a higher quality of the evidence. And all of these, of course, standards are the commissioners apply based on, you know, their understanding of them based on the evidence presented. But I just wanted to go through all of that since I know there are commissioners that joined this year as well. So if anyone has questions there.
No, thank you. I
Okay,
appreciate
yeah.
it.
Of course.
Yeah, and I'll just offer a comment. Caitlin, I really appreciate this practice of just taking issues that arise in the course of our meetings and addressing them with a thorough examination. That's reflected in your memo here, just as both as a housekeeping tool and also as an educational tool. So thank you.
Yeah, thank you.
The next item on the agenda is some civil penalties to discuss.
Mr. Chairman, there was a comment made by a commissioner at the end of the last meeting that on these assessments, it may be best. There's no legal reason. It's just a historical practice that all of these are read off. I can simply draw people's attention to the documents.
Oh, sure.
As long as people view that as sufficient. As no one has any concerns with that. It's legally sound, so.
No objection here.
Yeah, no
I think-
objection.
No one wants to hear me list a whole bunch of names. Thank you.
The only thing that would be helpful is if we had the amount in there too.
Yeah. Yeah, in the civil penalty assessment documents you have, it shows.
Oh, I was looking at the agenda. My
No,
apologies.
you're fine. We have under each heading, you can see
Yep,
what the
yep,
form was
yep.
and who was assessed the penalty.
I think this is great.
Yeah, so there's some.
Whoever suggested that was really on it,
Yeah.
wasn't they?
Yeah, that sounds just fine to me. I guess the only thing that I would maybe comment is there anything about any of these that is noteworthy?
I mean, candidates and treasurers, there's a couple, there's a few, there's several for PACs and just a few for lobbyists. That's it, that's all it is.
Okay.
It's also much faster. Thank you for allowing us to increase our efficiency.
Yeah, absolutely. The next item on the agenda are we have 5 civil penalty waiver requests.
Yes, as a reminder, we obviously have not adopted anything the subcommittee has done. I know no one is confused about that. I'm saying that for the purpose of minutes that we are still operating under our historical practice of penalty waivers. The first is Eugene Bradley. Mr. Bradley is a lobbyist who received a reduced penalty at the last meeting. He was able to pay the reduced amount, but his payment was on day 31, I believe, instead of day 30. He's asking for an extension. We have received the payment of the reduced amount. I would recommend granting the extension.
I would move we accept that.
I'd second.
Motion has been seconded to grant the civil penalty waiver request. Do any other commissioners have comments? Hearing none, all in favor of approving the waiver request, the motion for the waiver request signify by saying aye.
Aye.
All opposed, say nay. The motion passes.
Next one is Jacob Bach. He asserts several reasons for his penalty waiver. Primarily, we're talking about mail delay, zeros, and he didn't actually raise or spend anything. He's unable to pay and is attempting to terminate as well, which I believe we're working with him on right now. This meets our historical hardship analysis, and typically the commission would grant or at least partially grant this. It's a $350 penalty. They have not received one previously, and they were running for Wichita School Board. I would recommend granting this, which would be fairly in line with historical practice on the way the commission dealt with this form of hardship previously.
Are there questions? Do any commissioners wish to make a motion?
I'll move that we waive it.
Thank you, John. Do we have a second?
I'll second. It's Kyle.
Thank you, Kyle. Any additional discussion? We'll take a vote. All in favor of approving the motion signify by saying aye.
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 All opposed, say nay.
Nay. Which got to you, John? The senior citizen on this, or what was it?
Nothing got to me. I just think it's the thing we got to do.
The next item is Anthony Gallardo.
We're going to skip Anthony Gallardo because unless he is present in the room, I don't see him in the room, and he's not on Teams. He received the Teams info yesterday. I'd like to give him another opportunity at the next meeting. We'll give him a little bit more time with the Teams info.
We need
to
action
join.
on that.
We do not need action to skip it and just add it. We'll add it to the next month's agenda.
Okay.
The next is Ann Rollins, unless there's an objection to skipping Mr. Gallardo.
No.
Ms. Rollins was assessed $350 in her candidacy for city commission. She asserts a medical reason. We historically approve medical claims on penalty waiver requests. I would recommend similarly approving this waiver request. This person has also not previously received any waiver requests.
Questions, comments, motions?
I would make that motion to waive.
Thank you, Kyle. Do I have a second?
I'll second it.
Second.
Thank you, John. Any additional discussion? All in favor of approving the civil penalty waiver request with respect to Ms. Ann Rollins signify by saying aye.
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 All opposed, say nay.
Nay.
The motion passes. Thank you, Jane. We next have a Matthew Wells.
I think this one's a little tougher than some of them we dealt with this meeting. Mr. Matthew Wells was running for city commissioner. He was assessed $350. He originally received the wrong affidavit from the county clerk. When he signed, we can't accept an affidavit that's for the wrong election cycle. That's what happened. Or for the wrong office. I think actually in this case, it was an affidavit for offices outside of our jurisdiction. We can't accept that affidavit because it does not assert the same things that is required for us to accept an affidavit. So because he received the wrong affidavit, we immediately, like we always do, send a letter informing them that they signed the wrong affidavit. Here's the correct one. Please sign and submit this one. Unfortunately, it appears he left the country to go on a mission trip and was out of the country. When he did get, I can't assert whether he received that mail before he left or not. He doesn't really say anything about that a whole lot. He says that he was gone when the letter was sent. What I will say is when he did get back, he did seek to resolve it as quickly as possible. We did confirm that he went to the county clerk's office when it was closed. He attempted to file it even that day, but no one was there for him to actually sign and provide it. And immediately after that, he did actually provide it. So because of his efforts to ultimately submit the proper form, And that he, as far as we can tell, did everything he could to submit the proper form, even though he was out of the country. I think this is one that under the new guidance would not be granted a waiver, but the new guidance doesn't apply today. After talking to the local desk on this, I would recommend approving this waiver request.
Have we ever had a waiver request that includes pictures before?
I think it's happened, but it's not incredibly common. I would mention that I don't think the pictures are relevant. But no, I don't
Said
think
that with a straight face.
I don't think that we've received many waiver requests with pictures before. I don't think it's a first, but it's pretty close.
We know if Mr. Wells is in any of these pictures.
Yeah, I believe he is in. I believe he's in the second picture. I think is him.
The one with the first figure?
I believe so. I think the printed documents may also only have some partial pictures as well, in case that's
Okay.
if that's important to anyone's. If that's important for anyone's waiver requests, we'll make sure we submit the full pictures for everyone as well. But it looks like the print just cut off a little bit when we turned it into a PDF.
I find it speaks to credibility.
Can we subpoena that iPhone the guy's holding in the shed? Because perhaps that would be the mayor on the other side, kind of an artist taking a picture
Perhaps.
of an artist.
So
Well,
the recommendation after talking to the local compliance desk on this, and we had a good discussion on this, the recommendation is to approve this waiver request.
Noted. Do any commissioners have further questions, comments? Do any commissioners wish to make a motion?
I'm sympathetic to the recommendation of the executive director, but I'm not going to make the motion. Someone else will have to if someone desires to waive this or waive part of it.
Okay, so we will expect to see Mr. Anthony Gallardo as a bullet on our next meeting.
Yes.
Okay. Unless anyone has any further comments, this concludes the civil penalty waiver portion of today's agenda. We next have executive session. Director Skoglund, do you know how much time we should reserve for executive session?
I think you all have seen the materials. I don't think it's particularly long, but I don't think there's a lot to discuss, but if you think that there is, then maybe a little longer. I don't know. Maybe I would say 10 minutes.
It's 1:48 now. Let's say 2.
Okay, 2, whatever. Yeah. And you can hold it.
I can come back.
Yeah, exactly.
There
Okay,
you go, Kyle. That's your cue.
it's your time to shine, Kyle.
You know what? I move that the commission recess this open meeting, to executive session with conflict counsel Jay Rodriguez present to discuss matters related to confidential investigations pursuant to KSA 25-4165 and for good cause as provided by KAR 19-6-2. Justification for recess to executive session is to consult with counsel for the commission, which would be deemed privileged in the attorney-client relationship pursuant to KSA 75-4319, subparagraphs B and 2. The open meeting shall be resumed here at 2 p.m.
And
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor? Yeah, I have 2:10 now.
Bingo.
Yeah, you're good.
Mr. Chairman, I would move to find sufficiency on complaints 255 through 755 through 760.
second,
Motion has been seconded. The motion is to find sufficiency with respects to matters 755, 756, 757, 758, 759, and 760. Is there any additional discussion for the motion that has been seconded?
I would note that Commissioner Berger has some concerns about the information and belief language, which he's going to discuss with council, and I guess that's all I know.
Yeah, so let's take a vote. All in favor of approving the motion to find sufficiency signify by saying aye.
Uh,
Aye.
Aye.
All opposed, say nay.
Nay.
Okay. The motion is
Mr. Chairman.
passed. Go ahead, John.
I would move that we dismiss complaints number 746 and 747.
Thank you, John. Do I have a second?
I'll
I'll
second.
Thank you, Jerry. The motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to dismiss complaints 746 and 747 signify by saying aye.
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 All opposed, say nay. The motion passes.
Mr. Chairman, I would move to find the probable cause on complaint number 748.
Thank you, John. Do I have a second?
Second.
Thank you, Jane. Any additional discussion?
Clarify the motion.
Yes, the motion is to find probable cause with respect to complaint 748, and it has been seconded.
Would it be set for a hearing at the next meeting? That is the usual course, but I want to make sure that I'm correct on the motion.
Yes, we will set a hearing for October 25th with respect to complaint 748.
Does he want to name a hearing officer now?
Okay, all in favor of approving the motion signify by saying aye.
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 All opposed, say nay.
Nay.
Thank you, Commissioner Berger. The motion passes. Turning back to the agenda, we only have to announce that our next meeting is on October 25th in 4 weeks. Are there any other matters to discuss at this time?
You want to appoint a hearing officer, Mr. Chairman?
You know, not at this moment.
Okay.
I'd like to talk with Director Skoglund about that, as I know we've begun to put together a framework and a plan to try to divide some of those responsibilities, and I'm not quite sure where that lays, but
Okay.
we will try to determine that in advance of our next meeting.
And if I can ask for, probably not for the next meeting, because that's going to be, well, maybe it's better pre-election, but sometime in the next several meetings, if the staff could start to look at and report as to where kind of the geographics or the demographics of location and type of race for where we're finding more violations than not. So maybe we can start to tailor effort toward problem areas, whether that be local elections, you know, races that are local or state or whatever. I don't even know.
Can I take these statutes with you?
Yes.
Okay, that
Will do.
Does
Thank you.
that sound all right, Mark?
thanks for that. Yeah, for the helpful comment. I presume Director Skoglund heard that. So anything else before we take a motion to adjourn?
Thank you.
Do I have a motion to adjourn?
So moved.
Thank you, Jerry. Do I have a second?
Second.
Thank you, Andrew. Any additional discussion? Okay, all in favor of approving the motion to adjourn signify by saying aye.
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 All opposed say nay. The motion passes. This concludes the September 27th meeting of the Kansas Governmental Ethics Commission. Thank you, everyone. Paige, Caitlin, Mark, Jay, commissioners, thank you for your attendance,
Oh, shoot.
participation. It's greatly appreciated. We'll see you at the next one.
I meant to
Thank
say it
you
on the
all.
record, but any beauty that was found in those forms we put together is 100% Paige's credit.
Okay.
She